Welcome to Police Academy Prep. This is Deputy Z. Today we will be going through the Law Enforcement Basic Recruit Book of the Police Academy, going into Chapter 3, Legal. This will be the short edition recorded version where I breeze through the bold and highlighted points and terms in the chapter to provide a more streamlined, full recap of the chapter. The short version is great for situations like short drives to the academy on exam days. Be sure to watch the in-depth recording version where I read from the entire chapter and provide insight to potential test questions and real-life situations, as that version will be the one that fully prepares you for the test. Let's go ahead and jump into the material here. This is a very large chapter. I'm going to do my best to keep this 30 minutes or less, so I will be breezing through. So buckle in. Let's go for it. The things I cover will be strictly what I expect to be on the test. There will be some things that I don't cover, so make sure you read, do your flashcards, listen to the full extended version, etc. Your duties as a law enforcement officer include responding to calls, patrolling, determining violations of laws, making arrests, knowing how and when to use force, and investigating crimes. You must have a basic understanding of federal, state, and local laws in order to act properly and effectively without infringing on individual rights. Okay. There are several types of laws that govern the way we live in the United States, and one source of these laws is the U.S. Constitution. The U.S. Constitution establishes the form of government in the United States, and it also outlines the representational government and its responsibilities within a three-branch structure. Okay, you have the legislative branch, responsible for creating laws. The executive branch, which you are a part of as a law enforcement officer, is responsible for enforcing the laws, and the judicial branch, which is responsible for interpreting the laws. Those three branches make up the federal government. Constitutional law further defines the powers and limitations of each of the three branches. Florida has its own state constitution that generally parallels the U.S. Constitution, and what that means is it provides the same level of rights or greater to Florida residents than the original U.S. Constitution. So again, legislative branch, Congress, Senate, House of Representatives. Executive branch, us as law enforcement, president, vice president, cabinet. Judicial branch, Supreme Court, federal court. Statutory law is written and enacted by Congress, state legislators, or local governing authorities in response to a perceived need. It includes criminal, civil, administrative, and regulatory laws. Criminal law identifies behaviors deemed unacceptable by society. It also sets punishments for those behaviors. Ordinances are laws enacted by a municipality or county government. Local governments create ordinances that regulate matters of narrow application, such as curfew for minors, restrictions on the hours when alcohol may be sold, or parking regulations. And these ordinances only apply in the jurisdiction in which they were created for. Civil law is the legal action that a person takes to resolve a non-criminal private dispute with another person, such as child custody, landlord-tenant, and property boundary disputes. Administrative law is the body of law that establishes the operations and procedures of governmental agencies. So for us, it'll be the Florida Administrative Code, the FAC, which governs the training and certification of law enforcement. Do not get confused with FDLE or the CJSTC. The Florida Administrative Code governs the training and certification of law enforcement officers. Case law is the body of law formed by the decisions of the court system, which is part of the judicial branch. Court decisions influence how you perform your duties, so stay up to tune. Make sure you know the examples of not to listen to: Wikipedia, newspaper, media, etc. Make sure you follow agency policies and updates, legal updates, Florida statutes, Office of the Attorney General of Supreme Court for updated case laws. Make sure you're aware of your agency policies and procedures. As a law enforcement officer, your main objective is to protect the constitutional rights of everyone within the United States. The Constitution defines your authority to act. Again, the Constitution defines your authority to act. The articles of the Constitution form the Constitution's main body, and their purpose is to form a contract between the people and the legislative, executive, and judicial branches. The articles also spell out the responsibilities and authority of the three branches of government. All people stand equal before and under the law. The Bill of Rights are the first 10 amendments of the U.S. Constitution. Make sure you know that the 1st, 2nd, 4th, 5th, 6th, 8th, and 14th amendments are of particular importance to law enforcement. All right, so we have the First Amendment, the right to free speech. The Second Amendment protects right to bear arms. The Fourth Amendment protects from unreasonable search and seizure. Fifth Amendment protects against self-incrimination and guarantees due process. Sixth Amendment establishes a right to speedy trial, impartial jury, and assistance of counsel. Eighth Amendment protects against cruel and unusual punishment and prohibits the use of excessive fines or bails. 14th Amendment establishes due process and equal protection of the laws. Do not confuse the 5th and 14th Amendment. The 14th Amendment establishes due process, and the 5th Amendment guarantees due process. In regards to the 5th Amendment, due process means the laws must be applied fairly and equally to all people. Substantive due process is fair and consistent enforcement of the law, and procedural due process are the procedures that must be followed to protect people's rights. The term offense means a breach of law and broadly describes criminal or non-criminal acts that are punishable under Florida law. An offense for which the only penalty may be a fine, forfeiture, or other civil penalty is a non-criminal violation, also known as a civil infraction. Non-criminal violation does not constitute a crime and is not punishable by incarceration. Usually it's a traffic violation, such as failure to yield right away. Municipal and county ordinances can be criminal and or non-criminal. So your criminal ordinance violations can carry up to 60 days or a $5 fine or both. A non-criminal ordinance can be any amount either below or under $500, any amount. A misdemeanor is any criminal offense that is punishable by a term of imprisonment in a county correctional facility of up to 1 year, including 1 year. So 365 days or less is a misdemeanor. Okay, second-degree misdemeanor, the max you get is 60 days in jail, $500, or both. A first-degree misdemeanor, maximum 1 year in jail, or $1,000, or both. A felony is any criminal offense committed where the maximum penalty is death or incarceration in a state correctional facility for more than 1 year. A third-degree felony, 5 years and or $5,000. Second-degree felony, 15 years and or $10,000. A first-degree felony, 30 years and or $10,000. A life felony has varying penalties. It could be up to life incarceration, $15,000, or both. Capital felony is the highest class of felony. It could either be death or life in a state prison without parole. And make sure you know the examples for those. Let's move to... Okay, we're moving to reading the Florida statutes. So, again, make sure you know where the chapter is, the section, the subsection, and the paragraph. So, the chapter is going to be basically the title. Everything in the subsection outlines the actual crime itself. And subsections can be broken down into paragraphs, which specify the elements of the crime. So again, subsections are the actual crime, and then the paragraphs are the elements of the crime. Know what an enhanced penalty is. It is a sentence that is increased from one classification of offense to a more serious classification due to prior conviction or the serious nature of the circumstances involved. So, violent offenses against law enforcement, wearing a mask or hood, prejudice or discrimination, using a weapon while committing a crime, unlawful taking, possessing, or using of a law enforcement officer's firearm, or committing a misdemeanor or felony that facilitated an act of terrorism. Then we have parties of the crime. A principal in the first degree is a person who commits any criminal offense, whether felony or misdemeanor, that aids, abets, counsels, hires, or persuades an offense to be committed or attempted. So if it's the partner, remember they don't actually have to be unseen. They could be in the van hiding somewhere doing the tech portion. That is still principal in the first degree. An accessory after the fact is a person who gives the principal any aid with the intent that the principal avoids or escapes detention, arrest, trial, or punishment. So, for example, your friend knows you're in trouble. He hided you in his garage, and they find him. He's going to be an accessory after the fact. Okay. So, before a person can be charged with a criminal offense, 2 questions. Was a crime committed? Was there an intentional criminal intent? So, criminal intent is the conscious decision someone makes to deliberately engage in an unlawful act or to harm someone else. Probable cause is a fair probability or reasonable grounds to believe that someone committed a crime based on the totality of circumstances. You have your categories of criminal intent. General intent is when a suspect intentionally commits an illegal act prohibited by law without considering the results of the act. Battery, assault, rape, kidnapping. Specific intent is the intent to commit a crime and the intent to deprive an owner of something permanently, whether that be burglary, embezzlement, forgery, etc. And it refers to the individual's state of mind. Transferred intent is when a crime is intended to harm one person and you accidentally harm somebody else. I go to punch Joe and I accidentally hit Bob in the face. Recklessness. This imposes criminal liability on defendants when they did not intend for behavior to cause or resulting harm. Usually is an example of negligence. Negligence is the failure to behave with the level of care that a reasonable, prudent person would have exercised under the same circumstances. Elements of negligence: a duty to act with care, breach of the duty to act, causation or proximate cause, and then the damages. For the damages, you have two types of damages. The first one is compensatory, and the second one is punitive. Compensatory damages are designed to compensate for the actual damaged property, harm, or injury that the plaintiff suffers. You have general damages, are those presumed to result from the defendant's actions, pain, suffering, discomfort, humiliation. And special damages are those actually caused by the injury, lost earnings, medical expenses, destruction of property, attorney fees. And then you have punitive damage. Those are meant to punish the defendant and warn others from doing the same thing. You can get both punitive and compensatory damages. The U.S. Constitution guarantees a right of privacy to all individuals. Identify three types of encounters: consensual encounters, investigative stops, and arrests. Consensual encounters are nothing more than simple conversations. Consensual encounter occurs when you have voluntary contact with a person and they are free to go at any time. And they're free to refuse to answer questions. They don't have to identify themselves, etc. You can't use lights and sirens, things like that. An investigative stop. You can only make an investigative stop if the officer has reasonable suspicion that the person stopped is committing, or is about to commit a law investigation. And it is conducted for the limited purpose of investigating that reasonable suspicion. If you don't find any, it's over, done, you gotta leave. Reasonable suspicion is the standard of justification needed to support an investigative stop. This means that you can articulate or put into words facts that support a suspicion that the person stopped may be involved in a law violation. Know what a bolo is: a description of a vehicle or suspect and any other information that would help identify the suspect. Terry stop and frisk, that is Supreme Court case Terry v. Ohio. Know that basically, let's see here. Where's the description? Okay. So Terry frisk does not violate search and seizure. You may frisk the exterior clothing of someone lawfully detained if the officer has reasonable suspicion to believe the person is about to commit a crime, has committed a crime, or is committing a crime, and may be armed. Two elements for pat down or frisk is the person is lawfully detained based on reasonable suspicion, and the officer has reasonable suspicion to believe that the person possesses a dangerous weapon. A frisk is not restricted to a person's body. It could be the passenger compartment, it could be their bag, etc. An officer who conducts a valid stop and frisk, as described above, and in the process feels an item readily recognizes contraband, may seize that contraband, known as the plain feel and the plain touch doctrine. This rule allows the officer to seize the contraband even if it does not feel like a weapon. Contraband is anything that is illegal to produce, possess, or transport. Again, you cannot manipulate or grope when it comes to the plain touch and feel doctrine. The duration of a Terry stop is limited to the time reasonably necessary to accomplish the purpose of the detention. Pretext stop. Wren v. United States. If an officer has probable cause to get you on a traffic stop, they can then look for other things inside the car. That is a pretext stop. Okay. Arrests are the most serious level of encounter and can involve lengthy searches or detentions. The standard of justification required to make an arrest or conduct a search is probable cause. Okay, Illinois v. Gates established the totality of circumstances standard of probable cause. So again, totality of circumstances with probable cause is Illinois v. Gates. Okay, let's see what else we got here. Know what proof beyond a reasonable doubt is. That is for the courts. Basically, that proof beyond reasonable doubt that they committed the crime is the standard used to determine, right, if they're guilty. Fourth Amendment guarantees a search occurs when an officer intrudes into a place where a person has a reasonable expectation of privacy. A seizure occurs when an officer affects a person's right to have or control their property, usually by physically taking it. A seizure is also a physical arrest or detention. All right, let's see here. Search warrant is a court order that authorizes law enforcement to conduct a search and seizure, and it protects people's rights. Dun, dun, dun. Okay, exceptions to search warrant requirements. Okay, there's three elements to be a search: government, intrusion, and reasonable expectation of privacy. Know that for the test. Probable cause is required when you have a warrantless arrest. Exceptions to that would be plain view, mobile conveyance, and exigent circumstances. So you only need probable cause. You don't need a search or an arrest warrant for these. So plain view, any contraband an officer can see can be seized without a warrant as long as 3 conditions are met. The officer is lawfully present, the item is in plain sight, and the officer has probable cause to believe that the item is contraband. Mobile conveyance. Vehicles and other mobile conveyances must be licensed, registered, insured, and easily moved. Consequently, they have a reduced expectation of privacy and may be searched without a warrant. Know what the Carroll Doctrine is. A mobile conveyance search does not have to occur at the same time as a stop. Probable cause is required for a mobile conveyance search. That is the Carroll Doctrine. That is Carroll v. U.S., which states the scope of the search under the Carroll Doctrine extends to the entire vehicle and all containers where the evidence can reasonably be found. U.S. v. Ross justifies probable cause in the search of a lawfully stopped vehicle to include the search of every part of the vehicle and its contents. Exigent circumstances are certain emergencies such as evidence destruction, an emergency scene, or a fresh pursuit that justifies a warrantless entry. So again, exigent circumstances, you have evidence destruction, an emergency scene, or fresh pursuit. Fresh pursuit is the immediate and continuous pursuit by officers of a suspect who is fleeing to avoid arrest. The offense has to have occurred in the officer's jurisdictional boundaries, and there are 3 conditions that have to be met. Probable cause that the suspect committed a serious crime, immediate or continuous pursuit of the suspect, and probable cause that the suspect is in the premises that is being entered without a warrant. And know that any contraband or evidence in plain view found when you're entering a place during fresh pursuit will not be suppressed in court. There are 4 additional search warrant exceptions requiring less than probable cause or nothing. So, for example, a consent search, that's just them giving you consent. Inventory of a vehicle. Administrative searches like a hospital, a law enforcement agency, etc. And then search incident to arrest. Consent searches do not require probable cause, reasonable suspicion, or even mere suspicion. You're just asking. Voluntary means a reasonable person under the circumstances would feel that they could refuse the request to search. Then you have consent. Third-party consent to search may be valid if the third party has mutual access and control of the area to be searched. In cases involving juveniles, the consent of the parent or guardian will generally overrule objection by the child. And also know that consent may be withdrawn at any time during the search. Inventory searches. When the driver of a vehicle is arrested, you must make sure the vehicle is properly secured. Next is important to do an inventory, etc. Liability. Administrative searches generally do not require a warrant due to the setting or special conditions, and also are subject to search. Search incidents to arrest. When a person is lawfully arrested and taken into custody, they may be searched without a warrant. U.S. v. Robinson noted 2 historical rationales for the search incident to arrest exception. 1, the need to disarm the suspect to take them into custody, and 2, the need to preserve evidence for later use at trial. Chimmel v. California defined the scope of search incident to arrest as the arrestee's person and the areas within the arrestee's reach at the time of the arrest. However, Thornton v. U.S. clarifies that a search incident to arrest may also include the vehicle in which that person was arrested, a passenger just before the arrest. So Thornton v. U.S. is if they just got out of the vehicle, they're walking away, you can still search that vehicle because they were just in it. New York v. Belton, the scope of the search incident to arrest includes the entire passenger compartment and all containers located therein, locked or unlocked. Arizona v. Gant has further refined the scope of search incident to arrest situations involving vehicles. Officers may search the passenger compartment of a vehicle only when the arrestee is unsecured and the passenger compartment is within reaching distance of the arrestee, or it is reasonable to believe the vehicle contains evidence of the crime within their reach. Banning property in open fields. Basically, they're not technically searches because there's no reasonable expectation of privacy. Curtilage. The enclosed space of ground and outbuildings immediately surrounding a structure of someone's home and the surrounding field. Now, fenced and posted fields are generally a higher degree of constitutional protection than areas that do not have them. All right, breezing through here, guys. Let's see what we're doing here. The Florida Contraband Forfeiture Act. The Florida statutes give law enforcement agencies the authority to seize and forfeit certain property known as contraband articles. Contraband articles include items that are illegal to possess, items used in the commission of a felony, and items purchased with the profits of felonious activities. Forfeiture is a civil proceeding in which the law enforcement agency asks the court to transfer ownership of the property from the defendant to the law enforcement agency. And then they can do whatever they want from there once they get it. In the state of Florida, a person younger than 21 may not purchase or transfer ownership of a firearm from a licensed importer, manufacturer, or dealer. These prohibitions do not apply to law enforcement, correctional, or military service members under that age. A person younger than 21 can still own or possess a firearm in accordance with Chapter 790. For example, a person younger than 21 may own or possess a firearm that has been given to them as a gift or obtained by other lawful means. A person younger than 21 can also buy a firearm from a private seller, but you cannot sell to someone younger than 18 unless you get consent from their parent or guardian. Okay, here we go. Okay, Florida's not an open carry state, but know what open carry means. Open carrying your weapon in public. Know about the concealed weapons license and how in July 1st of 2023, you can now carry without a concealed license in the state of Florida. Okay. Make sure you know what readily accessible for immediate use is. You know that securely encased means in a glove compartment, whether or not locked, snapped in a holster, not attached to the person, in a gun case, locked or not, zippered gun case, closed box, open container, lid, not lid, etc. Know what FCIC stands for, Florida Crime Information Center Database. Law Enforcement Officers Safety Act is a federal law that allows qualified and retired law enforcement officers to carry a concealed weapon in any jurisdiction in the United States, regardless of state or local laws. You have to have two forms of documentation: photo ID from the agency and documentation that certifies your qualifications with that firearm. Know what reciprocity is? That is where if you have a license in Georgia, you can use that weapons license in Florida and vice versa. Risk Protection Order, RPO, is a court order that temporarily restricts a person's access to firearms for up to 1 year in situations where they pose a significant danger to themselves or others by having firearms and ammunition in their custody. Laws of arrest. Authority to arrest, it's the Florida statutes. The Florida statutes give law enforcement officers the authority to make arrests. An arrest is depriving a person of their liberty by legal authority. There are two types of arrests in Florida law: arrest with a warrant and arrest without a warrant. An arrest warrant is a court order authorizing and requiring law enforcement to take the individual named in the warrant into custody to answer for charges specified in the warrant. Obtaining an arrest warrant requires an affidavit containing probable cause. Okay. You may warrantless arrest. You may take a probable cause arrest without a warrant under the following circumstances. The person committed a felony or misdemeanor or violated the county or municipal ordinance in the presence of the officer. The person committed a felony outside the officer's presence, but the officer has probable cause to believe that the person committed it. Or a warrant for arrest has been issued and is being held by another law enforcement officer or agency. Then you have your misdemeanor exceptions: carrying a firearm in violation of injunction, battery, retail theft, traffic offenses related to crash investigation, unlicensed carrying of a concealed weapon, disorderly conduct on premises of establishment, theft from a dining or lodging establishment, trespass on school grounds, possession of cannabis less than 20 grams, stalking, transitory evasion, criminal mischief, trespass on certain properties, acts of domestic violence, a violation of injunction for protection, and sexual cyber harassment. Notice to appear is a written order that may be issued by a law enforcement officer in lieu of a physical arrest, requiring a person accused of violating the law to appear in court at a specified time and date. Just know that you can't give someone a notice to appear if you can't identify their, you can't verify their identity, or they live out of state and they're probably not going to come back to this jurisdiction, if it's domestic violence, or if they had a previous NTA that they didn't show up for. Probable cause affidavit, also called an arrest affidavit, is a sworn written statement by a law enforcement officer establishing certain facts and circumstances to justify an arrest. Okay, the document is used by the judge to determine if there is sufficient probable cause to detain the individual. Use of force. Okay, officer use of force is restricted by case law, statutes, and agency policies, and it is unlawful to go beyond the force that is necessary in any given situation. 776.06. Well, actually, let's talk about the three levels use of force: basic physical restraint, less lethal force, and deadly force. 776.06 defines deadly force as any force that is likely to cause death or great bodily harm. Remember that on the test. Deadly force is also great bodily harm, not just death. Okay, remember that use of force by a law enforcement officer is serious and should be a last resort when de-escalation fails. You have to be able to articulate your legal justifications on why you did it. As an officer, you can only use the force reasonably necessary under the circumstances to accomplish your lawful objectives. Graham v. Connor, that is the use of force case. Remember, he's diabetic, running in and out of a gas station, and the cop thinks he's robbing the place. Tennessee v. Gardner restricts the use of deadly force on an individual fleeing from arrest. So it basically tells you can only, let's see. The court's test for the use of deadly force in making an apprehension considers the following justifications. There's 4. There's probable cause to believe the suspect committed a felony involving infliction or threat of serious bodily harm. The use of deadly force is necessary to prevent escape, and the officer provides a warning, if feasible, and an opportunity to surrender. And there is probable cause that the suspect poses a threat or death of serious bodily harm to officers or others. The use of force, including deadly force, is a seizure subject to the reasonableness requirement of the Fourth Amendment. Okay, Florida statutes on use of force. Here. Okay, 776.06 is deadly force, as we explained. 776.07 is escape from custody by law enforcement or correctional facility. Types of liability. Criminal liability occurs if a person is found guilty of committing a crime. Civil liability is responsibility for a wrongful act or an omission that injures a person or property and most often involves negligence. A tort is a civil wrong in which the action or inaction of a person or entity violates the rights of another person or entity. Torts can be intentional or unintentional. Unintentional as negligence, or intentional such as battery. Okay, negligence. We already spoke about this already. Unlawful arrests, unlawful searches, unlawful use of force. These are acts that lead to liability. Color of law. When an officer acts or purports to act in the performance of official duties under any law, ordinance, or regulation, they are acting under color of law. Okay, Section 242 of Title 18 of the United States Code, USC, prohibits anyone acting under color of law from intentionally depriving another person of a constitutional or other civil right. A civil rights violation happens when an officer unlawfully interferes with the fundamental rights of another person, such as the rights to due process and equal protection under the law. Agency liability. You have direct liability, arises in cases where the officer committed an intentional or negligent tort in violation of the employee's agency orders or policies. Direct liability may result from the following: negligent hire of an problem employee, negligent retention of a problem employee, failure to train, or giving them duties that they're not capable of performing. Vicarious liability is when a person or entity is held responsible for the negligent actions of another person, even though the first person or entity was not directly responsible for the injury. Okay, limiting liability and officer legal defenses. Make sure you know all of these. We have sovereign immunity, acting within the scope of employment, qualified immunity, good faith, reasonable manner, justified acts, and emergency doctrine. So sovereign immunity is derived from the common law idea that the king and his agents can do no wrong. Let's see. The sovereign immunity law provides one of the most important protections for government employees and law enforcement agencies. Acting within the scope of employment refers to the range of reasonable and foreseeable activities that an employee does while carrying out the employer's business. Qualified immunity protects government officials from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights. Acts done in good faith. Officers must be faithful to their duty and honestly intend to avoid taking undue advantage of others. Acts done in a reasonable manner. Officers must act in a reasonable manner when responding to any law enforcement situation. Reasonableness involves acting professionally within the law and agency policies and procedures. Acts justified under the law. Some seemingly forceful and offensive law enforcement actions can be justified under the law. This occurs in situations where case law or statutory law provides a defense for an officer's actions. For example, deadly force, use of force in riots, possession of controlled substances during a criminal investigation. Emergency doctrine. When an unforeseen emergency requires instinctive action, you are not required to use the same degree of care as when you have time to reflect. This is known as the emergency doctrine. But that does mean you cannot have reckless disregard of others. Okay, Florida court system. You have county courts. Know that there are 67 of them. Minor criminal offenses, county ordinances, civil cases under 50,000. Circuit courts, there are 20 of them. Domestic violence, probation, Baker Acts, search warrants, and appeals. Florida District Court of Appeals, there are 3 judges and they do not use a jury. The Florida Supreme Court are elected by the governor and there are 7 justices. This is the highest court in Florida. Now the federal court system. U.S. District Courts. District courts are the federal trial courts assisted by magistrates. Courts of Appeal. Here challenges the district court decisions from courts located within its circuit. Supreme Court of the United States is the highest court in the United States and the chief authority in the judicial branch. They are, let's see, the Supreme Court's most important responsibility is to decide cases that raise questions of constitutional interpretation. Okay, personnel of the court. The judge presides over the courtroom and decides questions of law. The prosecutor represents the government's case. The defense attorney represents the defendant's case. Each county elects a clerk of the court who is responsible for maintaining files and official court records and issuing subpoenas. The court administrator is responsible for the day-to-day administration of the court system. A jury is a group of citizens who determine questions of fact in a trial. A bailiff or a court deputy is a law enforcement officer who is responsible for security in the courtroom. A court reporter is responsible for making a record of the proceedings. And now we're going to go into court proceedings. Okay, first appearance hearings. The first appearance hearing must occur within 24 hours of the arrest. And the judge will appoint counsel if needed. Hearsay evidence is, let me see. Hearing or trial protocols do not allow hearsay evidence from something else. An arraignment. After the arrest, a hearing arraignment takes place where the charges are formally filed by the state attorney's office. Pretrial release. In a pretrial release, the defendant is released from jail pending the trial proceedings. Bond hearing. At a first appearance hearing, there may be discussion regarding bond and special conditions of pretrial release. Deposition. A deposition is an official court proceeding in which the people involved, with the exception of the defendant, provides separate sworn testimonies regarding the facts of the case to one of the attorneys, usually the defense or the prosecutor, before the trial. Off the record. Okay, do not answer questions that are off the record. Off the record refers to information not recorded in an official document during a court proceeding. Always assume that anything you say can be used at a later time. A suppression hearing occurs when the defense files a motion to suppress or to exclude certain testimony or evidence from the trial, alleging that your actions were improper and violated their client's rights. Pretrial meeting. In some circuits, a prosecutor will request a pretrial meeting with the victims, the witness, and the arresting officer. Trial. The defendant selects a trial by judge or trial by jury, unless the defendant is a juvenile. Juveniles are entitled to a trial by judge unless tried as an adult. A sentence hearing. A sentence hearing occurs after a trial. A sentence hearing can occur before a trial. The defendant pleads guilty or nolo contendere. Violation of probation hearing. The violation of probation happens when an offender does not abide by all conditions ordered by the court. A violation of probation hearing occurs when an officer accuses an offender of violating their probation or community control and the offender contests the violation. All right, court orders. Subpoena is a legal order for a person to appear before a court, imposing a penalty if a person does not comply. A capias, a legal order for an arrest issued by the clerk of court at the request of the state attorney's office. An ex parte order, a court order issued and signed by a judge that is initiated by one person in the absence of without representation from the other. A pickup order is a court order to take a juvenile into custody. Protection order is a court-issued order that is meant to protect a person, business, company, establishment, or entity in the general public from harm or harassment. An RPO, a risk protection order, is a temporary ex parte order or a final order that revokes a person's constitutional rights to possess firearms. A domestic violence protection order is a court order issued by a judge to protect someone against domestic violence. Arrest by court order. Let's see here. Serving civil process, know that has to be done by a sheriff only, not local law enforcement agencies. And that concludes Chapter 3 Legal, the sped up version. Again, hopefully you're on your way to your test right now. You've already listened to the extended, lengthier version where I go into more details. It's less sped up. Sorry for this one being so quick, but in order to keep it under that time limit marker, I had to haul ass through that. So we're at 34 minutes here. If you are on your way to your test, good luck. You got this. Stay confident. Hopefully you've been studying and you are well prepared. You'll do fine, guys. Deputy Z signing off. I'll catch you in the next video.